I have now to sentence you for the offence of theft of a key on the 4th of January of this year, attempted burglary of a dwelling on the 8th of January, burglary of a different dwelling on the 7th of February, securing unauthorised access to a computer material with intent to commit an offence between the 3rd and the 9th of February of this year, and the corrupt and improper exercise of police powers and privileges, again between the 3rd and the 9th of February of this year. At the time of all of these offences, you had been a serving police officer with South Wales Police for over 10 years and had been promoted to the rank of sergeant. On the 28th of December 2023, you and other officers attended a sudden death at a property in Pencoed. £16,870 was seized from a safe in the property for safekeeping. It was being saved by the deceased for his funeral. It was counted, and that count was recorded on body-worn video. Outside the property, you spoke to Miss Price, who was the deceased's sister. She was not allowed to enter the property and was not aware that the cash had been seized. 2 days later, her nephews told her that the money was missing, and so she reported it to the police, who told her that they had seized the money. On the 4th of January 2024, while the officer who was tasked to return the money was away, you went to Miss Price's home to return the money to her. You counted it in front of her, and she signed to acknowledge receipt of the cash. She told you that she was going to put it in her safe. You asked to use her toilet, which was situated next to the front door, and then stole the key to the front door, which had been left in the lock. Later the same day, Miss Price realised that the key was missing, and she replaced it with her spare key. Your personal vehicle was seen in the same street later that evening. On the afternoon of the 8th of January, using a mobile phone that you had obtained for the purpose, you telephoned Miss Price pretending to be someone named Thomas from the coroner's office. You told Miss Price that she had to attend the Prince of Wales Hospital in Bridgend urgently, as there was an issue with her brother's post-mortem examination. She was on a bus on her way to Swansea at the time, but she made her way to the hospital in Bridgend. You telephoned her a second time to check that she was still on her way to the hospital. At the hospital, Miss Price discovered that no one named Thomas worked there, and that none of the staff had contacted her. In the meantime, having ensured by that means that Miss Price would be out of the way, you went to her address that afternoon, wearing black clothing and carrying a black Under Armour rucksack. You would not have been able to gain entry using the key that you had stolen, because the spare key was still in the back of the lock. When officers searched your home address on the 15th of February this year, they recovered a black Under Armour rucksack from your bedroom wardrobe and found Miss Price's missing front door key in the side pocket of that rucksack.
Buckle up, guys. This sentencing exposes a police sergeant who crossed every line. The judge lists theft, attempted burglary, a completed burglary, illegal computer access, and corrupt use of police powers. While trusted with duty, he seized funeral money, returned it, then stole a house key. He later posed as an official to lure a grieving woman away, trying to break into her home under false pretenses.
On the 6th of February 2024, you carried out searches on police computer systems into an address in Maesteg and the family that lived there. You did so because you had seen intelligence that suggested that £60,000 in cash was present at that address. At about 11:45 hours the following day, the 7th of February 2024, you went to that address. One of the occupiers, Miss Watkins, was at home and was in the shower. She heard 2 knocks on the door and then heard the front door being opened. When she opened the bathroom door, she was shocked to see you standing there dressed in full police uniform. You told Miss Watkins that you had a warrant to search the house due to suspected drug dealing. You had some paperwork, but she was not permitted to see it. You confirmed with her that there was no one else in the house. When Miss Watkins asked if she could telephone her husband, you said no and took the phone from her. You told her to remain sitting in the living room. You then went upstairs and located the family safe in the main bedroom. You brought the safe down and asked Miss Watkins for the key. She told you that she didn't know where it was. You asked her what was in the safe, and she told you that there were photographs of her grandson, some jewellery and collectible coins, and an unknown quantity of cash that belonged to her husband. there was estimated to have been about £16,000 in cash in the safe. You told Miss Watkins that you had to take the safe away to get your colleagues to open it. You told her that you could not give her a receipt as she did not know the contents of the safe. You took a note of her mobile number and left at 12:31 hours. Miss Watkins immediately called her husband, Mr. Bailey. He came home, collected the key to the safe and went to Bridgend Police Station to ask for his safe to be returned. At the police station, he was told that there was no record of police attendance at the address and the matter was reported as a burglary. At about 18:34 hours that evening, you telephoned Miss Watkins and pretended to be PC Roberts from Gwent Police. Miss Watkins asked if you were the same officer from earlier that day. You asked if she wanted a crime reference number and if she had a pen and paper, and then you hung up. On the 9th of February this year, you telephoned the South Wales Police Anti-Corruption Unit and said that you wanted to hand yourself in as you had done something stupid. You claimed that you had been blackmailed and were in fear.
The court describes a second target, where the officer used police systems to find an address believed to hold cash. In full uniform, he entered while a woman was home, claimed to have a warrant, blocked her from calling anyone, and removed the family safe. There was no real operation, no record, just deception. Later calls under fake names deepened the fraud before the crime was reported.
When asked what you had done, you said that you had done a burglary, that you had been tasked to do it by persons that you didn't know but that you feared. You said that those persons had requested you to go to an address and remove something, which you did. You said that you had removed a safe with unknown contents and left it on wasteland near John's Lane. When you were interviewed on the 10th of February following your arrest, you claimed that you were being blackmailed because of your involvement with a female who you named. You said that a Bridgend-based organised crime group may have been responsible. You denied entering the property in my stake as a trespasser, claiming that you had been invited in as part of a setup and that you had been given instructions on where to leave the safe. You were interviewed about the first set of offences on the 29th of April this year. This time you said that you were being blackmailed because you had sent sexual pictures of yourself to another man. Others had discovered your occupation and identity and demanded money from you, which you did not pay. There is no victim personal statement from Mrs. Price, but prosecution counsel has read the relevant part of her recorded evidence. Mrs. Watkins made a victim personal statement on the 10th of April this year. It has been read to the court by prosecution counsel. There is no need to repeat what prosecution counsel has read, but I take it all into account. You are now 34 years old and of previous good character. I take into account the sentencing guideline on the imposition of community and custodial sentences. Obviously, this offending is so serious that only an immediate custodial sentence is appropriate. Applying the sentencing guideline on reduction in sentence for a guilty plea, you are entitled to the full 1/3 credit for your guilty pleas at the earliest opportunity for the theft and the attempted burglary. You indicated not guilty pleas or no pleas for the burglary, the computer misuse offence and the police misconduct offence in the Magistrates' Court. At the PTPH on the 27th of March 2024, you pleaded not guilty to the 3 counts then on the indictment. You did not offer a guilty plea to any alternative offences. You asserted generally that you had been acting under duress. Stage 1 was fixed and later extended to the 30th of April. On the 2nd of May this year, the case was listed for plea, but you were not produced from custody that day, and so you were not able to change your pleas to guilty until the 9th of May. You are entitled to the credit that would be due to you if you had been able to change your pleas on the 2nd of May as you had intended.
He phoned anti-corruption officers claiming blackmail, then changed his story in interviews, blaming threats and secret contacts. The judge notes the guilty pleas, how sentencing credit works, and that prison is unavoidable. Despite partial admissions, his earlier denials and false accounts reduced the credit he could receive for several of the offences.
It has been submitted on your behalf that you are entitled to the full 1/3 credit for your guilty plea to count 4, as you pleaded guilty to that offence as soon as it was added to the indictment. However, you could have made an unequivocal indication of a guilty plea to this offence before that stage, or given an unequivocal indication that you accepted the facts and would plead guilty to an appropriate offence. You did not do so. Therefore, you are entitled you are not entitled to full credit. You will be given at least 20% credit for that offence and for the burglary and computer misuse offences. I have considered the sentencing guideline on totality. I will pass a sentence on count 2 that will reflect your overall offending and concurrent sentences for all other offences. When determining the uplift on count 2 to reflect your overall offending, I will take into account the fact that you are entitled to a full 1/3 credit for the theft and attempted burglary and adjust the uplift accordingly. Turning then to the sentencing guidelines for the offences. For theft of a key, your culpability falls into category A, higher culpability, because the offence involved a breach of a high degree of trust or responsibility. There was some degree of planning because you took it upon yourself to return the money in the place of the officer who was tasked to do so. The value of the stolen item was low and there was no significant additional harm, so it is category 4, harm. The guideline recommends a starting point of a high-level community order with a range from a medium-level community order up to 36 weeks custody. For the attempted burglary of a dwelling, this was high culpability category A because there was a significant degree of planning or organisation. It is category 3 harm as nothing was stolen, although had you gained entry, you intended to steal a significant sum of money. For an A3 offence, the recommended starting point after a trial is 1 year and 6 months, with a category range from 6 months to 3 years. The fact that nothing was stolen because this was an attempt has already been reflected in the categorisation of harm, and so there need be no further reduction for the attempt. For the burglary of a dwelling, I categorise this as high culpability category A, because there was a significant degree of planning or organisation. It is category 1 harm because the occupier of the property was at home when you committed this offence. For an A1 offence, the recommended starting point after trial is 3 years custody, with a category range of 2 up to 6 years. There is no specific sentencing guideline for the offence of securing unauthorised access to computer material with intent. I have taken into account the general guideline on overarching principles. This was a deliberate misuse of the police computer system in order to plan a dwelling house burglary, and so your culpability is high. The harm caused, which can include consequential harm, is high, given the dwelling house burglary that resulted and the likelihood of loss of trust in the police. There is also no specific sentencing guideline for the offence of corrupt or improper exercise of police powers and privileges by a constable, so I have again taken into account the general guideline and overarching principles. Counsel and I have not been able to find any authorities on sentence for this offence. However, I have considered the authorities for the analogous offence of misconduct in a public office. I have taken into account the Attorney-General's reference, number 30 of 2010, the Queen and Bohanan.
The judge breaks down the legal categories: high culpability, careful planning, abuse of trust and financial motive, misusing police databases to plan crime and impersonating authority seriously damaged public confidence. Guidance from similar misconduct cases stresses punishment and deterrence, especially when an officer betrays the badge. Harm to victims and to policing itself weighs heavily.
2010 EWCA Crim 2261, 2011 1 Criminal Appeal Report Sentencing 106, in which the court, having reviewed the earlier authorities, concluded that they illustrated 4 important principles. Only the first 2 principles are applicable in this case. First, punishment and deterrent are always important, because not only must police officers be deterred from misconduct, but the public must see that condign punishment will be visited on police officers who betray the trust reposed in them. Secondly, an incentive, usually but not necessarily money, inevitably increases the seriousness of the offence. It is those principles only that I have taken into account, as the offence and the circumstances of the offence in that authority are very different from those in this case. Your culpability for this offending is high. You made a deliberate, conscious and premeditated decision to commit the offence. The harm is also high. The harm caused to Mrs. Watkins is clearly set out in her victim personal statement, and the harm caused to South Wales Police and to policing generally is obvious, even in the absence of an impact statement from the police. All the offences, save for the theft of the key and count 4, are very significantly aggravated by the fact that you were a serving police officer and the consequent abuse of trust. That is not a factor that is specifically contemplated within the sentencing guideline for domestic burglary, and in my judgment could justify moving outside the sentencing ranges. The breach of trust has already been taken into account in categorising the theft, and it is part of the offence in count 4, and so will not be taken into account a second time for those offences. For the theft of the key and the attempted burglary, I have borne in mind that you knew that Miss Price was mourning the sudden death of her brother. I have taken into account the effect of the burglary on Mrs. Watkins. Apart from the theft of the key, all your offending is aggravated by the careful planning of the offences, and that the offences were committed for financial gain. In mitigation and reducing the seriousness of your offending, you have no previous convictions. For over 10 years before you committed these offences, you had a positive character and exemplary conduct, even beyond that normally expected of a serving police officer, having received 3 commendations. You reported your offending to the Anti-Corruption Unit. You made admissions in interview, although the significance of this is reduced because you claimed that you had been coerced into committing the offences, which is a basis that was not accepted by the prosecution and which you have abandoned. You expressed some remorse in the pre-sentence report, and I accept that you are now ashamed of your behaviour. For the computer misuse offence, I have kept in mind that, although there were a number of searches, those searches took place in a short period of time. I have also taken into account that your offending took place over a period of just over 1 month. I have also taken into account the references submitted on your behalf, your commendations, the contents of the sentencing note, and the mitigation advanced very ably on your behalf by Miss Rutter today. She has said everything that could be said to assist you. Stand up, please, Mr. Cook. Prior to the commission of these offences, you had a good character, a good career, and you were held in high regard by those who knew you. You have thrown it all away, and in doing so, you have tarnished the reputation of South Wales Police and of policing generally. However, your actions are no reflection on the very many police officers who uphold the high standards that you upheld before January this year. For the theft of the key, if you had been convicted after a trial, the sentence would have been one of 3 weeks imprisonment. Less the 1/3 discount for your early guilty plea, the sentence is 2 weeks imprisonment. For the attempted burglary, if you had been convicted after a trial, the sentence would have been 2 years, 6 months imprisonment concurrent. Less the 1/3 discount for your early guilty plea, the sentence is 1 year, 8 months imprisonment concurrent. For the burglary, if you had been convicted after a trial and to reflect your overall offending, the sentence would have been one of 8 years imprisonment concurrent. Less at least 20% discount for your guilty plea, the sentence is 6 years and 4 months imprisonment concurrent. For the computer misuse offence, if you had been convicted after a trial, the sentence would have been 2 years imprisonment concurrent. Less at least 20% discount for your guilty plea, the sentence is 1 year, 8 months imprisonment concurrent. For the offence of corrupt or improper exercise of the powers of a police officer, if you had been convicted after a trial, the sentence would have been 2 years imprisonment concurrent. Less at least 20% discount for your guilty plea, the sentence is 2 years, 4 months imprisonment concurrent. That means that your total sentence is one of 6 years and 4 months. You will serve up to half of your sentence in custody, and then you will be released on licence and supervision to serve the remainder of your sentence in the community. During that time, if you commit any further offence or fail to comply with the terms of your release, you can be recalled to custody to serve any remaining part of the sentence. If the statutory surcharge applies, the order can be drawn up in the appropriate amount and any error can be corrected administratively, as can any error in the collection order that I also make. Then that concludes the hearing. You can go with the officers, Mr. Cook.
Finally, mitigation is considered. Prior good character, commendations, eventual remorse and self-reporting, though excuses of coercion were dropped. The judge says he ruined a respected career and harmed trust in policing. Sentences on each count run together, leading to a total of 6 years and 4 months, with half served in custody and strict license after release. Like the video, subscribe to the channel, and we'll see you in the next video.